Hi, hello everybody. This is Uma from Success Law Classes. Today we are going to discuss POCSO Act case law. The Telangana High Court reduced the sentence of POCSO accused, saying minor's understanding of rape must be considered before relying on sole testimony for conviction. The title of this case law is Kattula Vasu versus State of Telangana Criminal Appeal number 783 of 2023, which was decided on 9th November 2023. Facts of this case law is the case of the minor was that she had gone to stay at her uncle's house for a few days, where the accused, her cousin brother, forcibly committed rape on her. A few days after the incident, when the father of the victim noticed a change in her behavior and questioned her about the same, the minor told her father about the incident. Immediately after this, the father of the victim preferred a complaint before the police and the victim was sent for a medical examination. However, it was submitted that since substantial time had passed since the incident, examination report did not reveal the presence of any semen and could only conclude that sexual act had been committed owing to the hymen of the minor being broken. The trial court had convicted the accused under Section 6 of the POCSO Act for penetrative sexual assault based on the testimony given by the minor girl. In the appeal, the Honorable High Court noted that Section 6 provided specific details as to what would constitute penetrative sexual assault. It was held that a duty was cast upon the court to ascertain whether the ingredients of rape exist in the present case based on evidence narrated by the victim. The use of word rape by the victim girl in the present circumstances cannot be made sole basis for the court to assume or draw inference that penetrative sexual assault had taken place, the bench observed. Court also noted that in most cases, a witness prepared for the cross examination by the prosecution is likely to narrate verbatim what was sought to her and encouraged trial courts to remove any ambiguity in witness statements by asking questions as contemplated under Section 165 of the Evidence Act. It clarified that asking such questions for removal of doubt would not tantamount to leading questions. Of that fact that there cannot be any leading questions during chief examination. However, in the cases of child witnesses who would already been under trauma, the happening can be clarified so as to make the statement of the victim basis for conclusion of guilt or otherwise of an accused. Seeking such clarification would not amount to putting leading questions to the witness during chief examination. The Honorable Telangana High Court, while modifying a rape conviction under POCSO Act based on the sole testimony of a minor, held that it is imperative for courts to ascertain whether a minor fully understands the meaning of rape before accepting her testimony as sole grounds for conviction, partly allowing the appeal while modifying the accused's conviction and sentence under Section 6 of the POCSO Act for imprisonment of 20 years to a conviction under Section 8 of the POCSO Act with imprisonment for a term of 3 years. A single bench of Honorable Justice K. Surinder held that when the victim is a child and in one word she states that rape was committed, it would become imperative in such cases when there is no other corroborating evidence to know from the victim girl as to what is meant by her narration of rape, The victim girl need not be humiliated in the court. However, the judge has to record his satisfaction that the victim child or girl has an understanding of what is meant by rape or what the victim meant by stating that rape was committed. The said understanding of the victim as to what is meant by the word rape by the court concerned is for the reason of the specific requirements given under section 3 of the POCSO Act 2012 as to what constitutes penetrative sexual assault and what constitutes rape under section 375 of the Indian Penal Code. Bench opinion that when a case is being tried under POCSO Act, the court may arrive at a reasoned conclusion based on corroborative evidence backing the claims of the victim. However, the mere use of the word rape by a minor girl who is 14 years in the present case does not explain whether the child had knowledge as to what would constitute rape. It is in cases of married women or the victim having knowledge about what constitutes rape to accept the statement that the victim was subjected to rape. There is nothing on record in the evidence of PW2 that she had knowledge about sexual act or what constitutes rape. Nothing specific is narrated by the victim girl except stating that the accused committed rape on her. Finally, the bench noted that based on the testimony of the victim, the accused could only be held guilty under Section 8 of the POCSO Act for sexual assault and not for penetrative sexual assault, and accordingly modified the conviction. The Honorable Telangana High Court partly allowed the appeal while modifying the accused's conviction and sentence under Section 6 of the POCSO Act for imprisonment of 20 years to a conviction under Section 8 of the POCSO Act with imprisonment for a term of 3 years. A single bench of Honorable Justice K. Surinder Sir. Thank you all. Please subscribe my channel, like and share this video. If you have any doubts, please comment.